The state's two most obvious points of contact with the average citizen are the public schools and the criminal justice bureaucracy. No matter how little you might be interested in government, whether as a student or a party to a legal proceeding, the state will intrude in your life whether you want it to or not. Schools, in principle, teach us to be citizens. The state has a compelling interest in raising generations of citizens with the knowledge and the sociability to function in society. But schools are not the only institutions that seek to educate us, that seek to shape us as people. The criminal justice system also teaches us something. To be sure, it teaches us to see the justice system as an essential aspect of society, one that benefits everyone. This is certainly what most of us are taught in school, since respect for these institutions is seen as an attribute of the good citizen. But as it is practiced, the criminal justice system teaches many Americans very different lessons. How to be anti citizens, how the state has the power to negate the citizen and turn that citizen into a subject under another's power. What does it mean to say that the criminal justice system is the major source of civic education for many Americans? Max Weber's classic definition of the state describes it as a ruling political organization that successfully upholds monopoly on the legitimate use of violence. The police are the most visible agents of the state, since they incarnate its right to use violence. The police are followed closely by the courts, which determine guilt and impose sentences backed by the power of the government. The violence part is obvious, but what about legitimacy? What does it mean to describe the police and the courts and their sanctioned violence as legitimate? On some level, we obey the law because we fear the consequences of breaking it. This attitude toward the law has nothing to do with legitimacy. Legitimacy comes into play when we obey a law or see to a law's enforcement because we believe that law is justified. The police and their actions are thus legitimate because they are the recognized agents of the law. The decisions of the courts are obeyed because those are the institutions charged with decisions about crime and punishment. Societies with governments and justice systems seen as broadly legitimate are societies that successfully socialize their members into this consensus. Socialization is the complex process by which we are all imprinted with the dominant values and customs of whichever society we are embedded in. This could refer to a broad category like being a resident of the United States, or something much more specific like being a student in the CUNY system. In each case, individuals are expected to learn and adapt to codes of behavior that are both explicit and implicit. There is a substantial difference, though, between socialization and education. Socialization suggests a broad, diffuse, and often passive process of internalizing standards of behavior. Our families socialize us, our neighborhoods socialize us, our schools socialize us. Often we have no real say over the content of our socialization. We are initiated into the world as it is and on its terms. Education is different. It is purposeful, directed, and systematic. It sets goals and it works toward them. Education in this sense is the true purpose of our schools, however often they fall short of it. The ideal remains what the philosopher of democratic education John Dewey said it was: to teach every individual how to recognize and apply their own abilities, to control their innate powers, and reject any force that would dominate or subordinate their independence. But we make a mistake if we assume that schools are the only institutions that seek to educate us. But in these cases, they aim to teach not independence, but dependence. They teach their students how to become the sort of people that serve an institution's needs, not the sort of people empowered to make their own institutions. Obviously or subtly, all sorts of institutions try to educate us differently, to turn us into the kind of people that suit their interests. This is how we have to think of the educational aims of the criminal justice system. Whether it be a school or a criminal court, all educational institutions have a curriculum, a coherent body of knowledge worth knowing, knowledge that transforms a person in line with the institution's aims. The criminal justice system, as it exists in the contemporary United States, offers us all an education in anti citizenry, and it focuses on three primary subjects: adjudication, punishment, and policing. Adjudication involves the court system. the mixture of bureaucracy and theater we recognize in the jury trial. Where would American popular culture be without the courtroom as a stage for high drama? The jury system arose in English common law. It was transported to the colonies and after the Revolution became the crown jewel of American democracy. Jury trials kept justice local and fair, and juries wielded great power to overturn decisions by judges thought to be excessive or cruel. Most importantly, the jury system was seen as a school for democracy. Even today, this belief lingers in a kind of ghostly afterglow, as anyone who has been called for jury duty can attest. Jurors were selected from the citizen body and given power over the life of the accused. To do justice required a juror to assess evidence, weigh motives, and draw upon their own sense of right and wrong. Jurors did this while learning the mechanics of the law itself, which in turn deepened their own sense of citizenship. After all, in modern democracies, the codes of law are a sort of guide to public life. To be a democratic citizen requires a working knowledge of the laws that rule the community, especially since democracy implies the role of ordinary people in making those very laws. This is one reason why American politics has been traditionally dominated by lawyers. This has always been the case, but we often forget until the 20th century there were no law schools. Lawyer politicians like Andrew Jackson and Abraham Lincoln learned their trade in frontier societies where anyone with the aptitude and will could read enough law to practice in the courts. In a society like this, the line between juror and lawyer was far thinner than it is today. But the limitations of this democratic legal culture remind us of how incomplete a concept American democracy was and remains. Women were excluded from juries until they began to win the right to vote in the early 20th century, itself a symbol of the intertwined concepts of citizenship and jury duty. Before 1865, slaves in the South were entirely outside the criminal justice system. They only became legal subjects in cases involving property. In the North, free black men were often also excluded, a practice that became standard in the South under Jim Crow. The Civil Rights Act of 1964 broke down these legal barriers, but the legacy of a racially determined legal system remains. Its foundations run very deep. While the jury system still exists, it has almost completely lost its role as a kind of educational institution. For one thing, even though the court system is clogged with cases, there are comparatively few jury trials of the type that feature on TV. 90% of felony cases in state courts are settled through a plea deal, in which a defendant pleads guilty in exchange for a lighter sentence than would be the case if convicted in court. Of the remaining cases, a third are decided by bench trials overseen by a judge without a jury. Most criminal cases are adjudicated through a complex, highly technical process that sidesteps juries altogether. The system runs, as it were, on autopilot, with occasional interventions by a key actor, a prosecutor or judge, for example, to pursue a desired outcome. Juries, with their potential independence of action, can be a liability in this case. Moreover, the pool of potential jurors is deliberately shrunk. I don't mean the kind of general cultural attitude that treats jury duty as a kind of bureaucratic punishment in itself. This attitude is bad enough, since it undermines any sense of jury duty as a public service. But much worse is the exclusion of citizens as potential jurors based on those citizens' prior experience with the justice system itself. I'm referring to the concept of disenfranchisement, which features prominently in Michelle Alexander's modern classic, The New Jim Crow. In many states, people who plead guilty to or are convicted of a felony permanently lose their right to vote, which by definition deprives them of the right to serve on a jury. This often features in the plea deals we discussed before. If a defendant is facing a trial in which losing means a 10-year prison sentence, the defendant may well leap at a deal which requires a guilty plea in exchange for a 5-year sentence. In this context, losing one's right to vote may appear a small price to pay for 5 years outside a prison's walls. Because our justice system systematically targets black men, about 1 in 8 of these men cannot vote or serve in a jury. Some evidence suggests that this mass disenfranchisement has affected election outcomes. It has most definitely affected the outcomes of jury trials. Punishment in 21st century America means incarceration. No country on earth imprisons as many of its own people as the United States. In fact, the very idea of the modern prison arose in places like the United States and France in the early 19th century, in societies that had undergone democratic revolutions that compelled them to completely reimagine their systems of justice. Prior to this period, jails really only existed to hold prisoners for trial or punishment. Punishment was physical. It involved maiming or mutilating or killing a criminal in retribution for their wrongs. Lesser criminals might be exiled or simply fined. The point is that there was no sense that criminals constituted a class of people in need of remaking, of re education, in order to make them socially useful. Under this order, crime was a violation to be made good through retribution. So you cut off the hand of a thief, you hang a murderer, you torture to death enemies of the state, and so on. Newly democratic societies rejected this as a relic of barbarism. Instead, they invented the prison as a place to segregate criminals from society and remold them as people fit for the community. One reason many American prisons are referred to as penitentiaries is that they sought to make criminals do penance for their wrongs, on the theory that this process of education would replace vices with virtues. Despite the fact that modern American prisons still cling to aspects of this belief, in the form of remedial schooling, religious instruction, and so forth, they are basically institutions of punishment. The post 1960s war on crime aggressively undermined the ideal of rehabilitation, and instead resurrected the older model of punishment as vengeance, but this time in the context of a much larger permanent prison system. In American society, which worships a very particular idea of freedom defined as the absence of restraint, the most appropriate form of punishment is the deprivation of that freedom, the imposition of a universe of restraints. If prisons merely hold convicts in a state of unfreedom, then they are serving their purpose as institutions of punishment. One interesting result of this model is the flourishing subcultures of what might be called prison society. Humans are compulsively social animals. We will find ways to live together under any and all conditions. This is as true of prisoners as it is of anyone else. Not only do prisons feature elaborately organized social structures, but these structures simultaneously exist outside of prison walls. So many Americans have done time, or still live under the authority of the system even on the outside, that prison culture cannot be hermetically sealed within the walls of any one prison. It interacts with, is shaped by, and helps to shape all of the other cultures that exist in our society. This system, by its very nature, cannot provide an education that nurtures democratic life. Its entire purpose is to restrict individual freedom. The first and unforgettable commandment a prison teaches is that the prisoner's life does not belong to the prisoner. Even when the prisoner's sentence is complete, they never recover the freedom to vote or serve on a jury, which is to say, they can never really be democratic citizens ever again. This unfreedom, like cancer, has a way of metastasizing. It is not just prisoners who find their freedom limited. Traditionally, juries had wide powers to impose a sentence as they saw fit. Harsh sentences, favored by prosecutors and judges, were regularly rejected by juries in favor of gentler punishments, a practice that signaled the role of grassroots democracy in American criminal justice. Beginning in the 1960s, this often freewheeling system was regimented by the introduction of sentencing guidelines. Specific crimes were assigned specific sentences, limiting the discretion of judges and juries. In principle, this was a reform that could have secured the rights of prisoners. Some juries and some judges could be unduly harsh, especially if a defendant's race or class marked them as something less than a citizen to begin with. Southern criminal courts were notorious in this regard, and sentencing guidelines could have helped alleviate these double standards. But in practice, sentencing guidelines served to reinforce existing inequalities. The most famous example is the sentencing disparity that existed between prisoners convicted of possessing or selling cocaine versus crack cocaine. Cocaine is an expensive drug usually associated with white users and dealers, often in the upper middle class. Crack was the cheaper, adulterated version widely available in poor black neighborhoods. A defendant convicted for possessing 5 grams of crack faced a mandatory minimum of 5 years in prison. To trigger the same sentence for cocaine possession required possession over 100 grams. Crack first appeared in poor black neighborhoods in major cities in the mid 1980s. It was immediately associated with the rising tide of violent street crime that dominated discussions of criminal justice in the 1980s. Violent crime across the country was, on average, 50% higher than it is now. In 1986, there were 2,016 murders in New York City. In 2020, there were 447 murders, and that was in a year widely described as one that saw violence in the city surge dramatically. It was easy then for a society already used to thinking of crime in racialized terms to apply the same logic to the so-called crack epidemic. The result was a dramatic influx of African Americans into the penal system on the basis of mandatory sentencing laws that effectively divided defendants by race. Moreover, there was little public debate on the nature of this epidemic. That a cheap and effective drug would be popular in neighborhoods devastated by long term segregation, economic disinvestment, and neglected infrastructure didn't seem particularly relevant. What mattered was that this drug was associated with violent crime, and violent crime was a problem to be solved by prisons. Consider the contrast to the opioid crisis, which kills Americans by the tens of thousands each year. The demographic profile of the average opioid addict resembles that of crack users in all particulars but race. That is, while opioids kill regardless of skin color, it is depicted as a crisis for rural whites and thus a medical issue rather than a criminal one. And of course, there is the persistent body of evidence that suggests that crack first made its way into American cities thanks to the Central Intelligence Agency, who took the profits it made steering low quality Colombian cocaine to crack cookers in inner cities and used those profits to fund their secret war against the revolutionary socialist regime in Nicaragua. Finally, the police offer their own education in anti citizenship. Police departments across the country rely on the public legitimation of their power by the citizenry at large, the people they supposedly serve. In principle, the police are empowered to uphold the law in a way that protects the freedom of everyone. Their own power is limited by no less an authority than the Constitution of the United States. In this view, individual rights are upheld in part by police exercising their legitimate powers. But the reality of policing teaches a very different set of lessons. Consider stop and frisk, the massively controversial NYPD policy that peaked under Mayor Bloomberg and officially ended under Mayor de Blasio, though the practice continues under the radar. In 2011, 685,000 New Yorkers were stopped by the police for no overt reason and searched for weapons or other illegal items. The stated goal of the strategy was to drive down crime in the most violent neighborhoods of the city, which so happened to be neighborhoods that were majority black or Latino. In fact, of the 4.4 million stop and frisks in New York between 2004 and 2012, 2 million of the people stopped were black men. Less than 0.5% of those stops yielded any weapons. Studies have shown that in a given year under the policy, a full third of the stops were entirely baseless. That is, in a system under which officers could cite something as vague as furtive movement as the basis for a stop, nearly 1 in 3 incidents could not be justified on even that weak a basis. If stop and frisk served an educational purpose, it could only be a negative one that taught those stopped what it meant to not count as a citizen, to be a kind of anti-citizen. If being an American citizen means enjoying the protection of the Constitution, what possible meaning could the Fourth Amendment's prohibition of unreasonable searches have for people profiled as likely criminals? The realities of the American criminal justice system are infinitely complex. But the fundamental dynamic and the fundamental tension of how to manage questions of crime and punishment in a free society, in a society that is always pushing toward greater freedom, remain to be solved.